Board Member Edgar. Board Member, oh, sorry. Board Member Julia Sumrock Fulkerson.
Here.
Vice Chair Robert Green.
Here.
And Chair Timothy Powell.
Here.
Thank you.
Here again. I forget it's green. Okay, great. So we get a wonderful opportunity, our annual Legal 101 by Carrie Richter, our new city attorney. Yay!
Thank you. Welcome, board member Sunrock Fulkerson,
You can just
correct?
Say, you can just say Fulkerson. Yeah, it's a mouthful.
So my name is Carrie Richter. I have been the city attorney in some capacity for the last 20 years. I'm just taking over as, I was the deputy city attorney, and now I'm the full thing. But I am also a trained historic preservationist. I have a master's degree in historic preservation, and I was a member of the Portland Landmarks Commission for 8 years, and also its chair.
Oh, wow.
So I do most of my volunteer work is for preservation causes, because it's really dear to my heart. So I have an affinity for you all and what you all do here, and so it means a lot to me to have an opportunity to come and do this. So my goal today is to provide a introduction and also some better explanation of the land use system and sort of how the Historic Review Board works here in Oregon City. It's an opportunity for you to ask questions and, about anything. We don't talk about applications that are currently before the HRB. But if there are areas of particular concern, I encourage you to interrupt me and we'll talk about whatever you have on your mind. I'm going to try to get through my 15 or so slides in less than an hour. So I'm going to move quickly. I've got some of you who've done this for a long time, forever, in fact, and you're new to Oregon, right?
Yes.
So, and Oregon land use planning.
Yes.
So I'm going to try to move quickly, but feel free to interrupt me as we move along.
Okay.
All right, next slide. So Oregon has a statewide land use program, which means that the state law sets a baseline for how we build and regulate land use here. And it builds upon itself through a series of federal, state, regional, city obligations that are all sort of reflected in the Oregon City Municipal Code. But they all deal with these various levels. So on the federal level, from a historic standpoint, we often deal with the Fifth Amendment Takings Clause. We deal with religious exercise, First Amendment free speech. We deal with the ADA and the Fair Housing Act. From the state level, we have the Oregon Revised Statutes, Senate Bill 100, which requires that all local governments have a comprehensive plan and a zoning code. State law sets the land use procedures that we have to follow when we're reviewing applications for development. There are special housing protective laws, and then there is an administrative agency called the Land Conservation and Development Commission, and they promulgate administrative rules. Those administrative rules include 19 statewide land use goals that identify particular objectives for land use in Oregon that then local governments decide to implement. Those goals run the gamut from goal 1, which is citizen involvement, to farmland protection and forest land protection, which we don't deal with so much in a city, but then there are also urban goals like industrial lands, infrastructure questions, and then the one that is at issue in historic preservation is goal 5, the livability goal, which deals with all the things that sort of make Oregon a great place to live, riparian areas, wetlands, historic preservation, scenic views, and the like. LCDC also has other rules that implement those goals, and so we have to follow those, and there are administrative rules that implement the historic preservation component of statewide land use goal 5. There are ODOT rules, and there are Department of State Lands rules with respect to wetlands. So that's sort of the state obligations that we have to implement here in Oregon City. Then there's the regional rules that come from Metro, and Metro is the regional government for the Portland metro area, and Metro sets the urban growth boundary. They handle urban reserves, and they have an urban growth management functional plan that sets baselines for things like riparian corridors. They don't deal with historic preservation too much, but they are, that's how the urban growth boundary works. Then we have the city regulations, and that's the bread and butter of what we do in these meetings, is implement the Oregon City Comprehensive Plan and MAP, which is the long-term vision for how we've decided we want Oregon City to grow. It has designations of land about how, what can be developed where, and it sets reviews of sort of, we're going to have conditional uses, and we're going to allow them in certain places. And then we implement all that in the Oregon City Municipal Code, which is this right here. And it sets forth the historic design standards that we review as criteria as part of our land use applications. Next slide. So, land use planning in Oregon City is broken down into 2 categories. We do long-range planning, which is what I mentioned, the part of implementing the comprehensive plan. So when we adopt a new comprehensive plan or we significantly change a comprehensive plan, that's long-range planning. And that's a type of decision called legislative decision-making. When you all amend your code to change how you want to conduct reviews or what criteria you want to use to conduct reviews, that's called legislative decision-making, and that's a political function, right? You're deciding what is best for the community on a bigger scale. In those kinds of legislative decision-making, the HRB is asked questions about what they want the code to say, and they make a recommendation, but it's the city commission that ultimately implements these standards. And there's no bias or ex parte context limitations when you're making legislative decisions. On the other side of the world that we work with here at HRB is development review. And development review is what we call a quasi-judicial or administrative review. So you're sitting as a judge, and you're reviewing a discrete development proposal for compliance against an adopted set of criteria. In these cases, Historic Review Board is the final decision maker unless the decision is appealed to the City Commission for further review. And because you're sitting as a judge, it's important that you are a neutral decision maker. And so we'll talk a little bit about what that requires. So next slide. Decisions in Oregon City fall, land use decisions for discrete development proposals, so we're talking about the quasi-judicial type, fall into 4 different types of categories, and this is set forth in the city code. If you look at what's allowed in a particular zone, you'll see that these are the things that are allowed outright. You'll see these things are allowed through conditional uses or require variances, and then the code has a table that says a variance requires a type of review, a type of procedure, and there are 4 types of procedure. The first type of procedure is a type 1 staff decision, and these are like building permits. If you just want a building permit that doesn't require land use review, you go into the planning office across the street and you submit your building plans, and somebody in the planning office checks off the box that says, yes, you're building a house in a residential zone. the house is this tall, you've met the setbacks, that's an administrative decision. It's over the counter, sort of a check the box review. There's no notice, no hearing or appeal. We have type 2 decisions, which are staff decisions. These are typically land divisions, so a partition or a subdivision, and design review outside of historic preservation are type 2 decisions generally, and those have a limited notice to neighbors, an opportunity for written comment, a decision by staff that's then appealable to the city commission. So those type 2 decisions don't come to HRB or the planning commission. Type 3 decisions are what you all hear. These are discretionary reviews to determine compliance with criteria. They require mailed notice to neighbors. They require a public hearing by the Historic Review Board and appeal rights to the City Commission. Type 4 decision are plan amendments and zone map amendments that are a single property. So if I want to change the zoning of my property, then I would go through a type 4 process, which is quasi-judicial, but it would go through the Planning Commission and then to the City Commission. So the next slide. So the procedure that's applicable to the type 3 decisions that you see start with an applicant filing a request for a pre-application meeting with staff, and that is where a person comes with a proposal and they sit down with one of the planning staff members and they talk about, you know, what will be required in order to process and review an application. Concerns that staff may have or areas where an applicant needs to take extra care are identified. The code requires a neighborhood meeting depending on the type of proposal. Do you have to have a neighborhood meeting with an HRB review?
No, as HRB as an overlay zone itself does not trigger it. It's when your development, like your site plan and design review for a multifamily or your commercial, that triggers it. So there may be historic elements to that, but historic on its own. So you do a lot of single family residential, that in itself doesn't trigger a pre-app.
Or a neighborhood meeting? Do most people do one?
It depends.
Okay, so if you want to have this pre-application meeting, you do, and then you put together an application and you file it. And what happens then is that the city has 30 days to review the application and do what's called deem it complete. And that's important because once an application is deemed complete, then that sets a timeline under state law for when the local government has to issue a decision, and it's 120 days. And that 120 days is not just for you to review and make a decision, but also City Commission to review and make a decision. And so that completeness determination is really critical for not just setting the timeline, but managing expectations over whether an application is complete. And the important part about a completeness check is it is not a determination that the application satisfies the standards, right? Because staff can't make that decision. The completeness check is to essentially look and see if all the things that would be necessary to satisfy the criteria are present. So if the application requires a traffic study in order to determine whether or not there is a site distance for a new driveway, then you would need to have that would have to be addressed in the application. And so staff would check the box and say, yes, there is that site distance calculation offered, whether it's by a traffic engineer or a civil engineer, that is present. Not staff isn't actually measuring that distance, or staff isn't actually determining whether or not the windows are appropriate, but there are plans that show the windows, so staff would deem that complete. It's just important that you recognize that just because it's been deemed complete doesn't mean it complies.
Carrie, so if the city says that it's complete, and within their 30 days, it starts the 120 days. Once they mail everything out, and let's say the neighborhood association sees it and finds that it's not complete, and reports that back, does the 120 days start all over again?
No. If the staff misses something and does it and deems it complete, we still have to process it within 120 days. It's a sort of legal line in the sand. Once we've deemed it complete, we can't take that back.
Oh, okay.
I think usually what happens if we notice something is missing after the fact, we notify the applicant and say, hey, we've noticed this isn't here. You might consider getting that because we're going to issue a staff report and we're going to notice, that it's not there. And we can't make a recommendation of approval without that thing.
Yeah.
Great, thank you.
Do you mind if I ask something?
Yeah,
too?
please.
So I'm in historic permitting, so some of this stuff is.
Oh, so you know.
Yeah. But is this also kind of SHPO rules, 30-day rules, where if a compliance or determination isn't filed or isn't communicated within that review period, is the person allowed to just go ahead with their project?
No. So this doesn't follow, so SHPO has its own rules.
Right, but I didn't
And
know
they're
if it was the same.
separate. They're separate and distinct. So the way this works is we have 120 days then to issue a decision. If we don't issue a decision in 120 days, the applicant has the right to go to circuit court. So they go to Clackamas Circuit Court.
Okay.
They would ask a judge to order approval. And if the judge orders approval, then they get to build. So it's not an automatic thing if
Okay.
we blow the 120 days.
Okay, not that that happens very often, but sometimes, we might not receive word back from SHPO, and then we advise our clients, that's a green light essentially. So yeah, that's.
Yeah, so it's different, but, yeah. But we try not to make that happen. We try not to have that be
Right.
the result. We have had that experience, and we did have to go to circuit court, and we did have to defend the historic review board's review of a particular project, and we were able to prevail, but it was an expensive and time-consuming and endeavor.
Right, okay.
So us watching the clock on the 120 date is something that all the planners are looking at. Luckily for Historic Review Board, we get the first hearing very quickly, but after 2 hearings, that's when we start working with the applicant. They have the ability to waive the 120 to see if we can get to agreement. Also, I want to remind everybody that there is a 14-day appeal period of any decision and a 20-day notice of any city commission appeal. So we're adding not only that, we're adding 34 days from the decision and then giving enough time to get on a city commission meeting, maybe twice, because oftentimes the city commission needs the second meeting to adopt their findings. So we're playing calendar. So 20 days seems like a long time, but not when you have to add all those pieces of the puzzle in.
Okay, so the application is deemed complete. Then we have to mail notice to property owners within, 300 feet? And the notice will provide information about when the hearing is. The notice also provides information about where an applicant where a party who's interested can find the staff report. The staff report is the staff's evaluation of the criteria. Again, staff is just, the reason we do staff reports is to offer a consolidated identification of the criteria and some initial evaluation of the evidence that the applicant has presented. We are not, as staff, trying to advocate for an outcome. We're just trying to help inform the Historic Review Board of the applicable criteria and what we have in evidence, just as an attempt to be helpful. Then the staff report is made available, and then we have the public hearing. At the beginning of the public hearing, Chair Powell reads a series of riveting legal disclosures to inform the public that what the hearing procedures will entail. They include a couple of critical elements. The first that I want to talk about is raise it or waive it. You have to, as a participant, raise an issue at every level of a proceeding or it is waived. So that means that if a person wants to argue that the windows are inappropriate, they have to raise it before you. They can't appeal the decision of the city commission and then for the first time raise the fact that the windows are inappropriate. The other thing that's important about your review is that you are the only body who does a de novo review. De novo means like new, which means anybody can bring any evidence to the table. When it goes to the city commission, if it's appealed, they review on the record. That's the opposite of de novo. On the record means no new evidence can come in. So if I'm the applicant and an opponent is concerned that my windows are inappropriate, I have to bring the specs of the windows or an actual, window in before you. I can't wait until we go to the city commission and then expect to bring my window details to the city commission. So I think that it's important for you to understand that so that when people come and testify, you ask them about the evidence now. You question them about that evidence now because they won't get an opportunity to provide evidence later. And the other thing that's important about your disclosures is that this right to impartial tribunal. So Chair Powell will ask as part of the hearing whether anybody has any ex parte contacts, conflict of interest, or bias, and we'll talk about what those are. But that going through that process is really important to ensuring the impartiality of you as decision makers. At the end of a hearing, during the initial evidentiary hearing, so this is the very first hearing, anyone has a right to request a continuance or what we call leave the record open, which means a period whereby a person can submit written testimony. The record open periods under state law are longer than when the HRB has regular meetings. So in the effort of getting timely meetings, we usually don't use that option. We usually just continue to the second meeting. This raises the problem that Christina said, you only meet, once or twice a month, once a month. So this can add 30 days to the process that we have to grant anyone who asks for any reason. So that's an important part of the time deadlines that we're under. Once the public hearing portion of the meeting has concluded, meaning we have taken evidence from everyone who wants to testify, the record closes. That means no more evidence into the record, and the HRB deliberates and makes a decision, and then there's a right to appeal to the city commission. Next slide. We talked about 120 days. We talked about the applicant controls the timeline, which means they can force the city to begin processing an application even if it's not complete. So if Christina sends the applicant a letter and says your application isn't complete, as an applicant, I can respond and say, I'm not giving you anything else, deem it complete. And the 120 days starts on the day that I write that letter. So the applicant is in control of the timeline all the time. The applicant, as Christina mentioned, can extend that deadline, but only the applicant can. The city can't extend it for them. So we approach the applicant, and Christina usually does, and says, look, here's our timing. Will you extend the 120-day clock? The 120-day clock extensions have to be in writing. And so if at a hearing, somebody says, I'll extend the 120-day clock 30 days, they need to email Christina immediately and make that confirmation in writing. And then we talked about how during the initial hearing, any person may request a continuance or to leave the record open. Questions about that? All right, next slide. So in a type 3 decision, everybody's got a different role. What's important to know about the applicant's role is that they bear the burden of proof, which means it's their obligation to produce the evidence to show you that the criteria are satisfied. They have to make the case. It is not the opponent's job to explain why that case is wrong or to produce evidence that is countervailing. It is the applicant's job to show you that the criteria are satisfied. And because they bear that burden, they get to speak first at the hearing and they get to speak last at the hearing. So in the procedures that Chair Powell follows, he asked the applicant, so we have the staff report first, then we have the applicant speak and they present their case. And then anybody who wishes to testify about that application can do so, and then the applicant gets a last word for rebuttal. And the reason why we give them that opportunity is because they have to bear the burden of proof. The planning and legal staff, our job is to advise and assist you in making a decision. And that means crafting a staff report. It means being available to respond to questions or concerns you might have, and being helpful during the hearing to provide the board members support in finding things in the code or talking about how the HRB has done things before, or just understanding the application and knowing where to find things to be helpful. Neighborhood groups and others, their job is to raise concerns in the framework of the applicable approval criteria. We can only make a decision as HRB members based on the adopted approval criteria. There are lots of things that we often hear in public testimony that has nothing to do with the approval criteria, like the person is nice, the use does good work, the church that does amazing work, I mean, it's always hard to criticize Mother Teresa's clothes, but that's the job we have here at the HRB, right? And so the addition to the church, we review just like we review any other application against the criteria. The HRB member's job is to interpret and apply the plans and regulations, to educate the public and provide a public forum for interested members of the community to talk about what they would like, their hopes and dreams for historic preservation, and also their challenges and what they'd like to see be different. It's important that you all do your homework in advance of the meeting, and that you are willing to make hard decisions and ask difficult questions. And really try to understand what the application has proposed and whether or not it complies with the criteria. Next slide, please. So I mentioned that as part of this, there is this right to an impartial tribunal, requires that decision makers do sort of 3 categories of things. First, decisions have to be based on the testimony and evidence that is part of the record. Which means you can't have a conversation in a grocery store about an application and then make a decision based on that conversation. The reason why is because nobody knows what that conversation was. Nobody knows what additional information you got during that conversation. And that's problematic because all of the evidence, all of the discussion is to happen during the public meeting here. So, So if you have an ex parte contact, which means any sort of information that you get related to an application that is before you, you have to disclose it during the hearing. So if you run into somebody at a picnic and they say, this application is terrible because of X, Y, and Z, the next meeting that you come to, you need to disclose that at this picnic on this date, a citizen approached me and wanted to express their concerns about this application. I told them, the best thing to do is to interrupt them as soon as you know what they're gonna talk about and encourage them to come to the hearing, right? I understand you may have concerns, come to the hearing on Tuesday, we'll talk about it. I really wanna hear what you have to say. If the information gets out before you have time to stop the person, or better yet, what sometimes happens, I've seen, is you read a newspaper article, or you see a blog post, or you see a next door post about an application, and you start reading it before you realize where it's really going. The best thing to do in those cases is just bring a copy of the blog post or send a copy to Christina, and then what we do is we put it in the record and then everyone knows it's there. If you have a conversation and the conversation is more than come to the meeting, you need to, during the time when Chair Powell asks if there are any ex parte contacts, you'll say, I ran into this person, they wanted to tell me that they think that the roof is too high and, the gable faces the wrong direction, and so you need to recount that conversation. Take notes about it if you need to after the fact in order to come to the meeting prepared to disclose what information you got from that conversation. And then what Chair Powell does is he asks the audience if anyone wants to follow up or ask further questions about that. And that's the opportunity for someone in the audience who has concerns or wants to know if perhaps you formed an opinion about that, or if you've done any independent research, or, to follow up with you to ask questions. So
it's not just an opinion piece, say if it's a blog, that's an opinion piece potentially, but it's also any information that you've been able to acquire outside of the board. So for instance, I just talked about the Oregon Historic Sites database and looked up the thing that's coming across the staff report that's coming to us next. And I looked up the inventory form and the site record in the database, and I was telling them about it. So is that considered ex parte contact?
that is an ex parte contact because you got information from somewhere else.
Okay.
So what you need to do when you pull that up, you need to send it to Christina,
Yeah.
and Christina will put it in the record and get it to the rest of you,
Got it.
because the rest of you haven't seen it.
Right.
So, am I correct that in viewing the information or gleaning the information from that database specific to an application, that's the ex parte that has to be disclosed? However, just generally sharing like, hey, you can get information from the Oregon database about different sites, that is not specific to a specific application. That's just general information for resources for us. Am I correct on that? So in other words, there's not a disclosure requirement unless it's specific to an application.
Correct.
Yeah.
Correct. If you're going to evaluate where there have been additions put on houses in the Kenema Historic District, or you're considering the compatible change proposal, and you're going to just learn things, there's no obligation. The issue is if you are obtaining evidence, which are facts, related to an application outside of the public hearing, that information needs to be in the record here. Because what we don't want to happen is for the record to be closed. And you all are deliberating, and Board Member Fulkerson says, on the historic inventory, on the State Historic Preservation Office historic inventory, it says X, Y, and Z, then the public doesn't have an opportunity to weigh in on that and say, that inventory form is wrong, that inventory form, doesn't tell the whole story, and here's why. The whole idea is if you are coming to this application with facts that the public hasn't had an opportunity to know about, then that's and it's influencing your decision, that's a problem.
So I did attend the ethics seminar here a few months ago, about communications and so forth. And he cautioned against even a board member talking with another, because then that board member could talk to another. He classified it as serial communication, if I remember correctly. So I asked him, I said, I understand that relative to specific applications where we have a quasi-judicial procedure, but I said, it would seem that for legislative procedures, we are trying to glean all the information we can, and so those discussions are not problematic. And he actually couldn't really speak to the difference between the two. He says, well, just don't do it.
So there's two different things at issue here. There is the right to an impartial tribunal for quasi-judicial decisions, which is a proposal is before you for development of a single parcel, right?
Right.
And in that case, we can't have evidence of outside influence, right?
Right.
And so, Board Member Fulkerson talking to you about the evidence she has obtained outside the public meeting is a problem. That's one problem,
Right.
okay? The other thing you're bringing up is public meetings law.
That's what he was addressing.
And ORS 92 is state law that regulates public meetings. And that law says that if there's more than three of, well, how many are there in total? There's five? Okay, so a quorum is three, right? So if there's more than three of you talking about city business, anything having to do with city business, then that is a public meeting. And a public meeting has to have minutes, and it has to have an agenda, and it has to have notice. So if the three of you are talking about a legislative thing, compatible change, outside of the meeting, that is a public meeting, and that's the serial meeting that he's concerned about.
Okay.
So if Board Member Fulkerson emails Chair Powell about something, and then Chair Powell emails you, and you email Board Member Edgar, that creates a public meeting, even though you all are not in the same room at the same time.
Right.
A question in this, I, as an example, I enjoy reading historical documents
I'm
about,
shocked.
and examining photographs and images and what was happening in different periods. And
Yeah.
so it's part of just kind of like an ongoing education. So to a degree, I might have come to some opinions from my studies.
Sure.
And now I'm wondering, how much do I have to disclose in that regard?
Well, you are a Historic Review Board member because you have qualification to understand historic design and integrity and character, and of course you read things because you're interested about them. But if you are reviewing an application and you say to yourself, this triggers for me this particular article or this particular thing I read, then you need to send it to Christina. If it is general though, and it's not specific to, if it's not specific to the application before you, then you don't have to disclose it. And I mean, I understand it, there's no bright line rule here, but if this is a fact very particular to this particular property, I just read a study that says this property had this on it. That needs to be disclosed.
And to be fair to the database, I noticed that in a lot of the staff reports, the planners have been referencing database. So I think it's something you all go to.
Just everyone knows the database and us share the same data.
Okay.
So it just maybe the output is different documents.
Right. Right. I've noticed it's very similar in the verbiage and yeah.
Okay. Other comments about that, or should we move on? Ready to move on?
Christina, I have sent you the thing. All right.
Okay, so the second thing is decisions have to be free of actual bias. And actual bias means that that you have pre-decided an outcome, that you are not free of independent thought on a particular proposal. And that can be because you hate that person personally because they don't trim their bushes, you know, the way you'd like to see them trimmed. Their kid was mean to your kid. You might hate that application because there is just absolutely no way you can review a Queen Anne house that looks like that in any circumstance. Everybody has biases, and particularly in historic preservation, we have strong opinions, right? But we have to be willing to put aside those strong opinions and review an application based on its merits against the review criteria. But if you feel like there is something either personal or just professionally that you cannot review an application, the reason we have 5 of you is so we have a couple to spare. We will ask you to step down. If you are in a circumstance where you feel like you might be biased, reach out to staff. They'll put you in touch with me if necessary, and we can have a conversation to talk about how we can best deal with it. Finally, actual conflicts of interest, that is a pecuniary interest. So if you or a family member stands to make direct financial benefit or loss from a particular proposal, if you did the National Register listing for this particular property and you've been hired as the consultant, you can't sit on that same decision. All right, other government ethics issues. You can't use your position or office for financial benefit. You can't accept a gift of any economic value of over $50 per calendar year. So don't let anyone go buy you a beer because those will rack up really fast. If you have questions about that, at the end of my presentation, I have the phone number for the Oregon Government Ethics Commission. They have people who are really, really helpful. And Jacob Wiley, the city recorder, has been doing this a long time, and I have too, so I'm happy to help you with any of those issues that might come up. Next slide. Public meetings, we talked about, a quorum deliberating to a decision. We talked a little bit about serial meetings. You just want to be really careful just not to talk about city business. I mean, you can certainly talk about, board member Egger read an article about, how the streets in Kanema were aligned, and you can send that around and, talk about it, at the next potluck. But if it moves into a city proposal, city business, and particularly an application before you, we want to not talk about it. And even during a break in a meeting, if we're not recording, you want to not talk about the application before you. You want to talk about what you did last weekend and, the lovely weather we're having. Public records, almost anything in writing is a public record, which means that it can be disclosed in a public records request. So I believe you all have Oregon City emails. You want to use Oregon City email for Oregon City business and use your personal email for personal business and keep those separate. at all times if you can. Next slide. We said that decision-making has to be based on the standards and criteria in the development ordinance of the comprehensive plan. We try to be really clear in the staff report about what criteria we believe must be applied. If folks think other criteria applies, we ask them to identify it. And so your starting point for every application needs to be identifying the criteria. So what is the measuring stick we're using to evaluate? Purpose statements are generally not criteria, but they can provide helpful context for interpreting criteria. I mean, the thing that makes Historic Review Board criteria difficult is they're very discretionary. And so it often helps to use the comprehensive plan policies or policy statements to try to sort of better understand. We are trying to implement the historic review standards and guidelines consistent with the City Commission's intent when they adopted them. So that's what we're trying to achieve. So focus on the plain meaning of the terms, and if you have thoughts about how a standard is interpreted during the hearing, it's a good idea to ask the applicant to get their position or have a discussion while the record is open amongst yourselves. I don't think that boards, planning commissions discuss enough amongst themselves during a hearing. You don't have to wait until the deliberation. You can ask questions, you can follow up on questions, you can have discussion amongst yourself. It's really helpful to participants to hear where you are, what you are thinking or what you want to know more about. Next slide. So after you have heard the testimony, you're going to deliberate and make a decision. The decision has to be in writing, and that decision has to do a couple of things. That decision has to identify and interpret the applicable approval criteria, and it has to identify the facts in the record that lead to a conclusion that a criterion is satisfied or not. And to follow up on the things we were talking about earlier, personal knowledge is not evidence in the record, so put your personal feelings aside. Denial of an application can't be based on facts that are not in the record. And where there is conflicting evidence, you all get to decide which evidence to believe. The standard that the Land Use Board of Appeals uses, and Land Use Board of Appeals is the appellate body who reviews land use decisions after the City Commission. So if you're unhappy with the decision that is appealed from the Historic Review Board to the City Commission, your remedy is to take it to the State Land Use Board of Appeals. The standard that the Land Use Board of Appeals uses when they're evaluating evidence is whether a reasonable person could draw the conclusion that the decision maker drew. So I like to think about that when I'm at this level too. Is the evidence sufficient that a reasonable person would believe that it is true? And if the answer to that question is yes, then you approve the application. State law also allows for decision makers to apply conditions of approval to an approval. So we often impose conditions of approval to ensure compliance. And so you'll see those in the staff report, but as part of your decision making, you certainly can adjust or alter or impose new conditions of approval. Next slide. So I've included a couple of examples of standards that require interpretation, just so you can get a sense. One of these, general compatibility of the exterior design, arrangement, proportion, detail, scale, color, texture, and materials proposed to be used in construction of the new building or structure. The words general compatibility couldn't be more discretionary, right? I mean, you could drive a truck through that. So it's helpful, I think, when you think about this criterion, to think about what compatibility means given the proposal. Where is this property located? What is around it? What does general compatibility in your mind mean what you can see from the street? Does it mean, is it a higher standard because everything around it is contributing? Is it a lower standard because nothing around it is contributing? The question of general compatibility and what it means for you really needs to be thought through and deliberate with every application. And general compatibility doesn't have to mean the same thing every single time. It means what you think it means at the time the application is before you. Comprehensive plan policies often serve as approval criteria in the HRB decisions. Encourage property owners to preserve historic structures in a state as close to their original construction as possible while allowing the structure to be used in an economically viable manner. Again, anything, you know, any situation could meet or not meet that standard depending on what lens you use to look at it. It's important, again, that you are thoughtful about articulating what that lens looks like for you. And you explain that in the decision. That's what helps the decision, that helps avoid this idea of arbitrary and capricious decision-making, which is often an allegation leveled against historic review boards, right? Good taste commission, right? That it's just arbitrary, it's what you like today. That is not what we're doing here. We are focused on integrity and compatibility and character and maintaining the integrity of our historic districts, and that's why we're doing this, right? Okay, questions about that? It's a hard job. Next slide. Conditions of approval. So we impose conditions of approval often that require modifications to projects, right? We say, you know, we want this gable to point this way. We want you to move your driveway this way. We want you to use siding with this kind of relief. So we impose conditions of approval. There are limitations to the city's ability to impose conditions of approval, and those are set by a test established by the U.S. Supreme Court that has to do with rough proportionality and nexus. So I'm going to take it out of the context of historic preservation because it's easier. But if I am building a single-family house, the city cannot require me as a condition of approval to build a whole new 3-lane intersection, right? Because that would not be proportional to the impacts of my project. So the city has to be careful when it's requiring changes in design that would be costly or difficult, that they remain roughly proportional to the impacts. This won't come up very often in historic design review because I'm proposing a project, right? I'm proposing a house and it has windows. And so if the HRB requires those windows to be made of a different material because those are more compatible, that is a function of the development. It is an impact from the development itself. But we want to try to be careful about requiring significant changes in design that are potentially very costly because we could be in a situation where we wouldn't have that rough proportionality. And so you just want to be aware of that when we're looking at lengthy conditions. The other thing I want to say that's really important, maybe more important than what I have on this slide about conditions, is that comes up in historic review board before the historic review board often is you need to be careful about adopting conditions that require major redesign that you haven't seen the plans for. It's one thing to say, to impose a condition that is change these windows from 1/1 to 2/1, right? You can visualize in your mind what 2/1 looks like, and it can be clearly implemented. But when we do conditions that require major modifications in design, we've often been disappointed with the results because we haven't been as clear in the condition as we wish we were, or we had in our minds something different than what was the outcome. So for example, an applicant proposes a 3-story building and you think a compatible design would be 2 stories, I would encourage you to, if time allows, have an applicant come back with a 2-story design so that you can actually see it and make a judgment of its compatibility in drawings before you impose so many conditions that you don't have in your mind whether compliance can really be achieved. Does that make sense? My final slide is recommendations for effective participation. This is really important because I want you to be courageous about this job and ask lots of questions. Ask lots of questions of staff beforehand to understand what the proposal is. And if you have concerns about a particular thing, raise them with staff in advance. There's nothing I like more than going into a hearing and knowing what the decision maker thinks. Nothing I like more.
And it's not ex parte contact to call the planner.
Right, you can have all the conversations in the world with the planners at our office and everybody who works at the city, as long as it's you yourself, not the group of you. Right? And ask questions that are open-ended. Ask questions to show your curiosity. Ask questions to clarify your understanding. Maybe it's not a question, but you phrase it as a question in order to have a dialogue with an applicant to understand what is motivating them. And that will help inform, whether or not the criteria are satisfied. Other suggestions, recommendations for effective participation? Christina? Sorry, I put you on the spot.
I always say, call staff early, when you get the notice and the agenda, read the staff report kind of right when you get it. Let it sit for a little bit, you'll read it again before the meeting, but it helps, and then that kind of can make you think, okay, what are the questions to ask staff? And we love emails from staff, and we're happy to have a quick call.
Anything? Look at us in the bright shirt brigade here. Any other thoughts, Jude?
We aren't afraid of questions. So yeah, I just reinforce everything that Carrie and Christina have said. Anything that assists with clarity assists with the process. So in one way or another. So
I have a planning commissioner in another jurisdiction who emails staff all of her questions that she plans to ask at the hearing to staff before she comes to the meeting, so that she can get staff's thoughts. And what is most helpful is then staff says, that's a good question, and then ask that question. Follow up with this question. So it can help refine the questions to make the meetings more efficient.
But the question should only go to staff and not to the rest of the commission.
Only to staff.
Right.
And use your Oregon City email when you email staff to ask the questions. Okay, my final slide is my contact information. I do not work at the City of Oregon City. I work for a law firm in downtown Portland, but I am always available. So your first stop needs to be planning staff, and if they think it makes sense, then I can assist as well. I look forward to working with all of you, and I'm happy to answer any other questions now or later, whatever comes up.
Great, any questions? Thanks, Carrie.
Thank you so much.
Sure.
And I just sent you Carrie's PowerPoint, so you have it, you should have it in your Oregon City mail.
Thank you. Okay, communications we have here? None? All right, well, then we will adjourn our work session. Thank you again. 5-minute break here, please, and then we will start our next agenda, just next meeting.